So the purpose of this seminar is to really look at the statutory test for strict liability of keepers of animals, which is the Animals Act 1971. This is notoriously tricky in order to be able to understand it and also to apply it. And then we're going to look at other causes of action that there may be. And one thing which is particularly current is dangerous dogs. We're going to look at the situation of injuries caused by dogs, in particular the type of dog. Also, when looking at the statutory test under the Animals Act, we're going to consider some latest cases. How does that change the test? Does it give us any insight? Those cases are on your screen now, the case of Schultz and the case of Ford. As the Animals Act gives a statutory test that provides for strict liability, the defences are very important, so we're going to consider those before looking at the other causes of action, if in fact there isn't an Animals Act claim there at all, before considering the kind of evidence you need for a claim involving animals or defending a claim involving animals, and giving you some practical tips. The two cases I referenced are particularly interesting because the Schultz and Ball case really clarifies and builds on Mervahidi, all about loose horses in the road. Does it really matter what the horse is doing? Think about that, and the answer will come up later. And also Ford and Seymour Williams, again horses, but horse riding in this case. Everyone knows it's a risk sport, but where does that risk lie? With the rider or with the owner? So because it's a strict liability test, the statutory defences are very important, as the court said in Cummings and Granger, and shouldn't be whittled away. The statutory defences are set out in Section 5, and it's wholly due to the claimant's fault. The claimant voluntarily accepted the risk. However, note, this defence isn't available to an employer if the risk was incidental to employment and it was the employee that was injured. Trespassers and animals kept for protection. Contributory negligence, of course. So contributory negligence, of course, is a reduction of any liability. Slightly different to Section 5.1, which would, I suppose, be 100% contributory negligence, which, as we all know, is not a thing. There were also defences available for keepers of dangerous animals. An example of the Section 5.3 defence against trespassers is the case of Cummings and Granger, which again is a case of its time. It's a case involving a yard, they said, in the East End of London, next to the Maypole pub, where persons of the roughest type come and go. That's what they said. They said it's no good having a gentle guard dog there. It's reasonable to keep an untrained fierce dog there. They had a big sign saying beware of the dog, and the claimant who was trespassing knew about it.